President, the Copyright Amendment Bill placed before us is a controversial one. The bill is controversial not only because of the proposed amendments in place, but copyright law itself has always been a controversial concept. If we wish to understand the debate amongst various stakeholders today and create an appropriate copyright legal framework which suits Hong Kong, which suits the digital era, the 21st century, we must first understand what copyright is. In the speeches which I have heard so far, with perhaps the only exception by my honorable learned friend, Mr. Martin Liu, no one has been able to engage in this kind of debate, which I've heard so far. And this is the debate before us. Copyright is a right created by law that grants the creator an original work exclusive rights for its use and distribution. This bill adds another exclusive right to copyright owners, that is, to communicate the work to the public. The copyright owner has a monopoly over that work. This is an inherent dichotomy in the objective of the copyright law. On the one hand, it aims to protect the rights of those who have created the work. The logic is that they will create more than when the value of their work is being protected. On the other hand, the law must be sufficiently liberal to promote further creation, not to stifle creativity. The way that copyright law deals with this dichotomy is to draw a line to disallow anyone other than the creator to deal with the work in any sense, unless consent from the original owner is obtained. Under the current law, together with the bill, not dealing with the work means much more than simply not dealing with the final product of the work. Let's take Spider-Man, for example. Marvel owns the story. Sony owns the characters. If you and I attempt to create another story similar to Spider-Man, there may be a risk of infringement. Copyright owners own much more than the final products. They also own the concepts, the ideas leading to the final product. The law actually freezes certain ideas into property and prevents others from dealing with it. But the law, with the effect of forbidding others to use certain ideas, is fundamentally in conflict with the process of creation. It is an inherent fallacy to say that creation should only be recognized when one creates from scratch. This is not how art, culture, or entertainment has developed over centuries. All creations come from ideas. For an idea to become an actual piece of work, the process would inevitably involve an ongoing flow of creativity. A piece of work can always be the inspiration of a new idea, which will become another piece of original work. Andy Warhol borrowed the Campbell can designs for his famous work, Campbell Soup. Classical music, Johann Sebastian Bach in the 18th century borrowed or copied from early Italian Baroque masters such as Vivaldi. Joseph Haydn borrowed from Johann Sebastian Bach. Beethoven borrowed from Haydn in his Symphony No. 1. All these composers and artists would be sued for copyright infringement should they be alive today. So the question that we should debate here today in this council with this bill is a chance to amend the copyright framework to promote creativity. Where should our law draw the line in terms of infringement? This line to prevent others from dealing with existing work is the right to protect existing work. Does the bill pending resumption of second reading today draw the line in the right place? I say there is great room for improvement to promote and further creativity, at least when citizens are creating for the sake of creating, not aiming for commercial profit or private gain. Our copyright framework has remained largely in favor of those who have created work since its invention has developed over time to catch up.
請你停一停，陳偉業議員。
主席，請你點算法定人數。
郭榮鏗議員，請你繼續發言。
Our copyright framework has remained largely in favor of those who have created work since its invention has developed over time to catch up with technological development in the context of protecting copyright owners. For example, apart from having the exclusive right to copy the work, the owner has been given an exclusive right to make available copies of copyrighted work. This was added when wireless transmission was invented, so exclusive right was given to the owner to broadcast their work in the air. Today, again, the bill is in front of us. It's trying to catch up with the advancement of technology by copyright owners and exclusive right to communicate the work to the public. This targets new technologies such as online streaming of copyright work. The UK has introduced this exclusive right of communicating the work to the public in 2003, so that infringement does not necessarily involve a copy of the work anymore. Quite obviously and truly, our copyright law is indeed outdated, and the introduction of such a right when the current bill proposal is long overdue. There is also adequate and actual protection for right owners in place, criminalizing those who distribute and communicate pirate copies to the public. So the current bill is rightly catching up with the technological development and does well in the context of protecting the rights of existing copyright owners. How about the other side of the coin? The alleged aim of copyright law to promote and ensure creativity. Everyone can have an idea, and everyone should be allowed to create. The right to create should not be an exclusive right which existing copyright owners can monopolize. This is particularly important today, where materials for further creation are so easily available on the internet. The internet has democratized the creative culture, turning used-to-be copyright owners like you and me into potential artists. Today, it is so easy for us to appropriate and sample music so that we too can produce remixed music. Today, it is so easy for us to take out clips from movies we like, make a collage and pay tribute to them. Today, it is so easy for us to Photoshop Spider-Man to mock somebody, perhaps a political figure. Today, it is so easy for me to sing my favorite song and then upload it to YouTube to share with the public. Foucault once said that any person interact with an art piece could be an author. The creativity of ordinary citizens should be recognized, and we should all be given a fair chance to create. In fact, in Europe and the US, lawyers and academics have argued that copyright law in fact stifles creativity in this digital era and advocated to the abandonment of the entire copyright regime. President, it is not my submission or my point that we should repeal the entire copyright ordinance today, but it is a valid debate that is ongoing in the rest of the civilized world. This demonstrates that the existing copyright regime, which focuses on the protection of the right owners with existing work, is very outdated indeed. We need a legal framework which promotes and encourages creativity in 21st century Hong Kong. And we have creativity. We should be allowed to create, more importantly, to create freely without the fear of being sued or prosecuted. This is part of our freedom of expression, which is guaranteed under the Basic Law. Sadly, the administration has chosen to adopt a very restrictive framework in driving citizens from creation and innovation. I'm very much aware that the administration has introduced additional fair dealing exceptions into the current bill. Section 39 on criticism, review, quotation and reporting, commenting on current affairs, and Section 39 capital A on parody, satire, caricature and pastiche. That these acts in principle would not be considered as copyright infringement if they are fair, mainly if they are non-commercial, non-derogatory to the original work. I admit that these additional provisions are improvements upon the current legislation, but I'm not satisfied that these amendments are good enough to promote creativity for two major reasons. First, these statutory protections are at risk of being taken away by private contracts. The administration refused to make such protection absolute in the context of civil liability. For example, when I say examples, these are of course hypothetical situation. But if you buy a copy of the Spider-Man DVD, Sony Pictures can put a statement on the DVD box to contract out of the statutory protection for criticism and parody. Facebook can in turn insert into the terms of use so that the users would voluntarily give up their fair dealing protection under the copyright ordinance to quote or comment on copyright work, use the work to comment on current affairs, and use the work for parody, satire, caricature, and pastiche. Freedom of contract, as we all know, is not absolute, especially when copyright owners have much greater bargaining power in contracting out of statutory protection than the users of ordinary people like you and me. Therefore, I propose a CSA to introduce a contract override provisions so that all such contractual provisions which attempt to limit the freedom of expression or contract out of our fair dealing provisions would be rendered invalid. Secondly, there is too much gray area in the bill which could deter average citizens to create. Whether all these secondary creation acts that I mentioned earlier would be protected under the bill if it is passed is a question unanswered. Acts of recreation or secondary creation, if they do not fall under the 6 fair dealing exceptions, may be still an infringement under the law, even though I only wish to share my artistic talent with no private gain or profit and do not wish to make any further money from the act of doing so. Why should a person be penalized under the existing legislation? Our law should recognize and give a fair chance to those who wish to create, particularly
With the
on the
Honourable
basis...
Dennis Kwok, please pause.
主席，請你點算法定人數。
郭榮鏗議員，請你繼續。
Thank you, President. Our law should recognize and give a fair chance to those who wish to create for the sake of creativity. I must take this opportunity to reply to what my colleague, Mr. Michael Tan, has said about my criticism of Secretary Greg So. I must emphasize that I expressed disapproval of Secretary Greg So's attitude because he was making a lot of misleading statements regarding the legal position of the bill to the press through the microphone outside this chamber, but refused to put the government's position on the record inside this chamber. For example, the Secretary rebutted my friend Fernando Cheung in saying that streaming and the playing of games online is permitted under the bill, but there is actually legal risk, which he has not mentioned. He's being irresponsible and misleading in trying to persuade members of the public to support this bill, when he should at least have the integrity of putting the government's position on the record in this council. The copyright law must also protect citizens from the risk of political and selective prosecution. Today, we have a bill which is making substantial, albeit inadequate, improvements to the current legislation, but it meets with great opposition from the public. The government is to be blamed for such phenomenon. There is a severe mistrust between the public and the government. In the past few months, we see questionable prosecutions brought by the government, and it is natural and reasonable for netizens or citizens to query the government's motive behind this legislation, especially when the proposed bill is unclear. My colleagues and I have also raised various concerns about the bill being too restrictive in the context of secondary creation, and suggest that the government should further improve this bill at the Bills Committee. The Pan-Democrats and myself have proposed several CSAs to remedy the inadequacy of the bill, the contract override provisions, UGC, and fair use. These committee stage amendments will be wide enough to cover all the not-for-profit secondary creation that the citizens or netizens are concerned about. I'll be happy to talk about these CSAs later. Is the bill in front of me a better version of the current legislation? Yes, it is, but it is nowhere close enough to being good to strike a balance between the rights of copyright owners and promoting creativity. Having certain additional but discrete fair dealing exceptions are improvements, but they're not good enough, and they are too conservative for 21st century Hong Kong. Hong Kong, which is aspiring to be the Asian center of creativity and innovation, having just established the Innovation and Technology Bureau, should implement a copyright regime which embraces creativity while protecting the rights of existing copyright holders. As a member of the Bill Committee of this bill, and having participated substantially in the deliberation of the bill, I regret to say that the current bill fails to achieve the purpose of promoting creativity in this digital era. I'm left with no choice but to oppose the resumption of the second reading of the bill to express my dissatisfaction with the current state of affairs. Thank you, President.